and then the judges can introduce themselves.
Good afternoon, everybody. My name is Ali Khan, and I am an attorney in Chicago. And actually, I'm also an alum of the program representing Illinois at the national competition back in 1998.
My name is Ben Glickman. I'm a supervisor with the California Attorney General's Office, also an alumnus of the program. I represented California at the national finals back in 1995.
Good afternoon, I'm Dan Taubman. I'm a senior judge on the Colorado Court of Appeals in Denver.
Could you please introduce yourselves?
My name is Carrie Jackson, and I'm a junior.
My name is Charlotte Donaldson, and I'm a junior.
My name is Rashad Brima, and I'm a junior.
My name's Lindsay Bader, and I'm a junior.
And my name's Ben Getchis, and I'm a junior, and our teachers are Matthew Fulford and Mandy Hostetter.
Wonderful. We will be doing question 1 today. So, I do not think the United States would come to an end if we lost our power to declare an act of Congress void. I do think the Union would be imperiled if we could not make that declaration as to the laws of the several states. What impact has judicial review had on federalism? Is judicial review a counter-majoritarian practice? Please support your position. What limits, if any, would you place on the practice of judicial review? You may begin.
Justice Holmes' emphasis on the importance of the Supreme Court's power of judicial review over state laws reflected his belief that such authority is necessary for federalism because it assures a uniform interpretation of the Constitution. His comments also reflect the Supreme Court's ongoing role in defining federalism. Judicial review, the power of courts to declare laws and actions of government void, was established on the federal level in Marbury v. Madison, 1803, and extended to state actions in Martin v. Hunter's-Lacey, 1816, and Cohens v. Virginia, 1821. Through judicial review, the Supreme Court has set forth how power is divided among federal, state, and local governments. While the balance struck by the Supreme Court has varied throughout history, our panel believes that generally, judicial review has strengthened the federal government over state power.
In the early Republic era, the Supreme Court issued several landmark cases enhancing federal power at a critical time, including McCulloch v. Maryland, 1819, which broadened the scope of the Necessary and Proper Clause, Article 1, Section 8, by upholding the constitutionality of the Second Bank of the U.S. Also, Gibson v. Ogden, 1824, expanded Congress's authority to regulate trade between states under the Commerce Clause. The post-Civil War period, however, saw numerous judicial decisions which constricted the Civil War amendments, thereby enhancing state power. This was seen in the civil rights cases of 1883, which found the public accommodations provision for the Civil Rights Act of 1875 to be unconstitutional, and in Plessy v. Ferguson, 1896, which upheld Louisiana's separate but equal state law.
Expanding state power continued until the 1930s, when the court shifted by upholding federal New Deal legislation with the Commerce Clause. The Warren Court followed this trend using the Civil War amendments in Brown v. Board, 1954, and Jones v. Alfred H. Mayer, 1968, to expand federal power by banning segregation and limiting state autonomy by banning discrimination in real estate. The Rehnquist Court in the 1990s and its successor, the Roberts Court, represented a shift towards limiting federal power by constricting the Commerce Clause in the 14th and 15th Amendments. Notably, NFIB v. Sebulus, 2012, held that the Affordable Care Act's central mandate can't be enforced by the Commerce Clause, and Shelby County v. Holder, 2013, struck down Section 4 of the Voting Rights Act of 1965 as it exceeded the 15th Amendment's enforcement powers.
Our panel believes the idea of 9 unelected justices overturning legislation adopted by democratically elected representatives to be counter-majoritarian, because the decisions can frustrate the majority. Although the court typically doesn't stray far from public opinion, the court's relative isolation from political pressure has allowed it to protect the rights of minorities that would otherwise go unprotected. The victories in Heart of Atlanta Motel v. United States, 1964, when the court upheld policies from the Civil Rights Act of 1964, and in Ogerbefell v. Hodges, 2015, when the court upheld same-sex marriage, only happened because the court is counter-majoritarian. Although the opposite was done in Dred Scott v. Sanford, 1857, and in Korematsu v. United States, 1944, demonstrating the court cannot always separate itself from policies and protect the minority.
Although critics of judicial review argue to restrain this power, our panel disagrees. Judicial review is essential because it protects minority rights, acts as a final arbiter of the Constitution, checks the other branches, and balances state and federal interests. New limits to the power would make the judicial branch ineffective at completing these purposes. Additionally, the judiciary already has strong limits from Article 3, including giving Congress the power to set appellate jurisdiction, as well as the cases or controversies clause, restricting the court to only ruling on a case if it is ripe and not moot, and also ensuring that the court won't give advisory opinions. The court also has self-imposed limits, including that the litigant must have standing, the court won't take political questions, must follow precedent, and only decide constitutional issues out of strict necessity. Most importantly, though, the court lacks the power to enforce decisions and relies on the other branches. Until there is an abusive nature to the counter-majoritarianism of the court, new limits aren't necessary. We're now open for questions.
Great. Well, thank you very much, guys. A quick question. You, in your presentation, mentioned that the court doesn't stray too much from public opinion. Why do you think that is?
Well, public sentiment acts as a beneficial to U.S. society as it gets modernized. So public sentiment is a big it's a big deal when it comes to the Supreme Court marking on decisions.
To add on to my colleague, some evidence of the court using public sentiment would be when they review past decisions. They're required to ask this question of reliance on how the public has relied on the past decision before they rule on the case. This is just evidence that the court does look into public perception and how the public views their different rulings. Now, they don't necessarily use them or use the public's view in all cases or all appellate cases, therefore, but we would argue that public perception is definitely a big factor.
Additionally, even in cases like Obergefell v. Hodges, which is previously meant or as thought to be a case where the court may have ruled against public opinion, a Gallup poll in 2015, at the time when the court was being ruled, found that 60% of Americans polled thought that gay marriage should be allowed. And this would be just addressing that the court typically does follow along with public opinion, even if it directly isn't just deciding what they want, what public opinion.
So you mentioned that judicial review is counter-majoritarian. Does that make it anti-democratic? Are those the same thing?
I don't think necessarily. I think the judiciary serves as a check on the legislative and the executive because they're counter-majoritarian. They're allowed to make decisions that the public may not support them because they're interpreting the Constitution and not have to be worried about being reelected because they serve for life. And I would argue that a lot of these limits to the judiciary branch that makes them counter-majoritarian doesn't make them anti-democratic because they're upholding the Constitution, which is necessary for a solid democracy to hold.
Also, to add on to my colleague, judicial review being counter-majoritarian does not mean it's anti-democratic because the counter-majoritarianism of the court upholds minority rights that would otherwise go unprotected, so that majority rule doesn't influence the judiciary's decisions and rulings. And so by this, it is making it actually more democratic because it isn't a majority rule that the founders feared.
When you read about more controversial cases pending before the Supreme Court, the media always reports that justices appointed by a Democratic president are likely to vote one way, and justices appointed by a Republican president are likely to vote the other way. So do you think that justices vote based upon their personal views or based on judicial philosophies or some combination of the two?
The justices are there for tenure, which means that they don't have to serve any certain political party when they're deciding their decisions because they don't have to be reelected. They are just deciding based on what is constitutional and what is unconstitutional.
How does that square with the reports by the media after cases are decided, where more often than not, they uphold what the media said before the cases were decided? In other words, that the judges have voted consistently with the way people anticipated they were going to vote.
Well, I think this, oh, sorry.
I cannot tell you what was going through the justice's head when they were deciding, but based on those certain decisions, I would assume that they weren't looking at the media and that they were just deciding based on what they thought was constitutional in that case.
And this is a key problem that Chief Justice Roberts sought to solve. And one thing that he was really famously noted to say was that the justices didn't have a party when they were on the bench. They discussed issues as equals, and so they didn't take party affiliation into account. And I think that's really important because just because they survey what the people say and tend to rule in that way, they don't always do so. And I think that's really important, a really important distinction to make, that the justices don't necessarily follow the party lines because of that.
Sorry about that. Do you think there should be term limits placed on Supreme Court justices?
To answer your question, I do not believe there should be term limits placed on U.S. Supreme Court justices, just because it is stated in the Constitution. So it would take an amendment for the for term limits for U.S. Supreme Court justices, and instead I'd offer a different suggestion for how the Supreme Court would look if there were term limits, where the justices who have life tenure would take on original jurisdiction cases, while a more newer justices, so a second bench, would take appellate jurisdiction cases. And so this wouldn't require a amendment, so it'd be easier for change in the Supreme Court, which is less likely if we put on term limits, because there would be an amendment involved.
So are you advocating the creation of like a second Supreme Court?
I advocate the creation of a second bench so that the justices, once they reach a time limit or years, like 20 years on appellate jurisdiction cases, they are placed in a second bench, which takes on original jurisdiction cases, while new justices come in and decide on appellate jurisdiction cases.
Adding on to my panel member on the previous question about should there be term limits, I don't think there should be term limits, and it would cause more of like political tensions if there were term limits. They would most definitely increase political scrutiny, and there would most definitely be ideological shifts if there were term limits in the Supreme Court.
So in your presentation, you talked about the self-imposed limits that the court has put on itself, and you mentioned a few of them. Could you talk more about that? Which of those do you think is the most effective in limiting abuse of judicial review?
Sure. There's a lot of self-imposed limits, and a lot of limits that rely on Article 3 as well as self-imposed limits to fully make that limit to the power. An example of that would be that the court won't take political questions and must follow precedent. There's definitely some grounding in Article 3 from that, but it's also a lot of self-imposed limits. And the idea behind this is that the judges or the justices don't want the other branches to have to limit the power further. They realize that the judicial branch is meant to be the least powerful branch with neither the purse nor the sword. And so if they continue to limit themselves, then it will stop the other branches like Congress or the presidency from having to limit the power further.
To add on to my colleague Ben, Hamilton stated in Federal 78 about how the judiciary does not have the power of the purse and the sword. And this is stating that the courts were never meant to have a significant amount of power. The courts don't need a significant amount of limits on themselves because they were never meant to have an extreme amount of power, and therefore don't need to limit themselves to a certain extent.
Is the political question doctrine an effective limitation on a wonderful question, but I don't have time to get an answer or even finish asking the question.
A round of applause for the students for their hard work. And now the judges have their feedback.
Well, first of all, again, good work and congratulations for being here. I know it's not always easy to be on that side, and you have to work hard to be here. So, feel proud about that. In terms of my feedback, I really liked how you all participated. I like some of the, cases you mentioned. I mean, that's the extent of it, right? I mean, I think I don't have too much, critical feedback from my standpoint. I wish maybe in terms of the term limit question, we had gotten, maybe a little more clarity. I was a little confused on the, second bench and the logistics of that and where that came from. I think I was trying to take that question in a different direction about, should there be term limits? Why or why not? And if so, how does that look? I felt like you kind of jumped ahead of me, and I didn't know how you kind of quite got there. So maybe a little more clarity on that would have been nice for me. But other than that, I really enjoyed listening to you guys.
Sure, I'll go. Yeah, I agree. I thought the prepared remarks, I thought did a very nice job. You had a lot of material in there. My notes could barely keep up trying to get down all the supporting evidence and citations you were throwing our way. I think I particularly liked your answer to the second sub question about the limits on judicial review, where you took a position that judicial review is essential for these 3 reasons. And we don't need more limits. There's already these limits, and you ticked them off. And you had some ones that we haven't heard often today. Standing, political question, the case or controversy requirement, et cetera. And so then you even got in the fundamental issue of they don't have an enforcement power. So I thought in a short amount of time, you got a lot of info there, and we could have spent the entire Q&A asking you various questions just about your answer to that one piece of the first question. So I thought that was very good. And on my question about is counter-majoritarian anti-democracy, I thought you guys did a very nice job on that answer. The notion that what they're doing is applying and upholding the Constitution, which in and of itself is necessary for democracy. And then second, that they're upholding minority rights that would otherwise go unprotected, the discrete and insular minority concept from Caroline Products, which ultimately makes society more democratic. I thought those were just 2 really good points that you got out succinctly and fully answered what I think is a fairly complicated or at least nuanced question. So I thought that was really well done. So nice job.
I also thought you did an excellent job. I particularly liked your tying in the quote from Justice Holmes to the view of federalism to try to make sure that the Constitution was uniformly interpreted throughout the country. We haven't heard that today, and I thought that was a good observation. You cited lots of cases, as Ben mentioned. In particular, you cited 3 cases that we haven't heard anybody else cite: the civil rights cases, the Jones v. Alfred H. Mayer Company case, and the Sebelius case. And so those are all good examples that you shared with us. In answering questions on the issue of whether the Supreme Court follows public opinion or leads public opinion, people have debated that for years. And while what you say about the Obergefell case may be completely correct, when the Supreme Court decided Loving v. Virginia, there was a Gallup poll that went the other way and said that most people opposed interracial marriage at that time. So the Supreme Court was in some ways ahead of public opinion in deciding that case. So we could have spent a lot of time discussing whether the Supreme Court should lead or follow public opinion, but your comments were well taken. I would echo what Ben said about talking about the limits on judicial review and talking about mootness, standing, and political questions and ripeness. I think we're all good examples of ways the Supreme Court can limit the cases that it decides to hear. So overall, I think you did a really nice job.
Thank you for judging.
Thank you for judging.
Thank you.
Good luck.
All right.